Welcome to Resource Law and Regulation with Peter Scott.
Welcome to Resource Law and Regulation with Peter Scott. Peter is the founder of Scott Law in Bozeman, Montana, where he represents landowners, businesses, utilities, and local governments in matters involving water rights and land use and natural resource regulation across the region. On this show, we break down how these legal systems actually work in practice. I'm Shamika Rhymes, and in today's episode, we're discussing easements, right-of-way, and utility corridors. Peter will explain what they are, how they affect property ownership, and why they often become a source of confusion or conflict for landowners. Hi, Peter.
Hi, Shamika. How are you?
I'm doing well. How are you?
I'm good. We finally got some snow and it's April.
I'm jealous. It's 80 degrees here. Let's trade. It's too hot here for me. Well, let's talk about these hidden limits on property. Peter, what exactly is an easement and how does it differ from full ownership of a piece of property?
Well, property law, Shamika, in school is full of sort of Byzantine terms like, rule against perpetuities or statute of frauds. But basically, property ownership or full ownership is called a fee title. And we're taught that it's a bundle of sticks. One of those sticks is the right to exclude others from your property. In the case of an easement, you're granting some use of your property. You can grant use of your property for the benefit of another piece of property. That's an in rem easement. Or you can grant individual persons use of your property for some reason. That's typically referred to as an easement in gross. So those are kind of the two broad categories. And what it is a titled interest in the use of another's property, either for your personal benefit in gross or for the benefit of your property in rem.
It sounds like easements can exist for many different reasons. So, what are some of the most common types of easements that property owners encounter in Montana?
Well, the most common is usually access, crossing one parcel to get to another. And that can be for access by vehicle. Sometimes it's access to drive cattle across another person's property, or to place a utility and transmit electricity. Or a very common easement in the state of Montana is a water right easement or easement for a ditch or conveyance. And we see those commonly in many, many land transactions.
Okay. Well, utility corridors and rights of way often run across private property. So, how are those rights typically created, and what rights do utilities actually have once those agreements are in place?
Yeah, I'll break that down into two broad categories. The utility rights sometimes are for transmission. These would be the large, big, heavy, tall poles that you see sometimes. But far more common for the average person is just a utility easement for distribution. And this is the power poles that may come onto your property. So generally speaking, they are put in place in one of two ways. Either the developer, during the platting process, establishes the utility corridors on a piece of property that's being subdivided for multiple lots, or it may be an individual property owner who wants power and or water, sewer to come onto their property, and they'll work directly with the utility to grant an easement to connect their improvements to the utility.
Well, when someone purchases land, how do easements usually show up during that transaction process? And is that something that buyers should be looking for before closing on a property?
Absolutely. Easements are unfortunately one of the most fertile grounds for dispute in the area of land use law. So I would encourage people purchasing property to do a good deal of diligence. They're going to want to see a survey, and they're going to want to see a title commitment with a list of the easements that have been recorded against the property. It's also important to inspect the property, which is why a survey becomes so important. A standard exception to a title commitment policy or title policy are any easements or uses of property that could reasonably be discovered by inspection. So, for example, if there's a trail going across your property and it's very obvious that it's in use, you're tasked with inquiring what that trail is there for, who's using it, and running that down so that there's no surprises.
That's a good point. Yes, no surprises later on down the road. Sometimes people discover that easement only after they've owned the property for a while. So, how did those situations arise, and what options might exist when an easement creates unexpected limitations?
Well, this is exactly why title companies are reluctant to insure against a third party's use of property because it isn't always recorded in the chain of title. In fact, very commonly in Montana, the ditch easements that I referenced are not recorded. They've existed sometimes for many generations and they're in use today, but they've never been recorded. And in the area of easements, we would call that an implied easement. And those arise two different ways. So, in addition to an easement that's recorded in title, an expressed easement, you can have an easement by necessity. If I sell you a piece of property and the only way to get to the property I sold you is across a property I own, you would be deemed to have an easement of necessity. The other category is one called an easement by prescription. And prescription is a legal principle that allows another person to develop a legal right to use your property through continuous, uninterrupted, hostile, and open or notorious use. In other words, it's against the other's title. It's obvious that it's being used. It's been used for a period of 5 or more years continuously for that purpose. That is a recipe for creation of what's called a prescribed easement. And these are actually in Montana protected by statute. In Title 70, Chapter 12, there's a provision that specifies the right of people to use their easements for maintenance and conveyance of water through ditches. So it's really important to understand when you're buying a piece of property, if you see a ditch across the property, to figure out whether it's in current use and by whom, so that you understand the likely existence of an easement in that case.
This is reminding me of a Netflix show with the trail. The I don't want to say the name of the show, but the neighbor was wanting to put a trail through people's backyards and stuff. Would that be also kind of considered an easement?
Well, not initially. If they did it without permission
Hmm.
and they sustained the use for 5 years with no objections, nobody argued that they're not allowed to be there. They didn't put up no trespassing signs or send them a letter to cease and desist. They could develop the right to use it over that 5-year period of time. So it's really important. I see this quite a lot. If some property owner nearby is asserting a right to use your property and you disagree with it, the time to address it is immediately
Hmm.
because the clock is now ticking. If they continue to use your property for their benefit and you don't stop them, they will eventually obtain a legal right to continue using it.
Well, disputes over easements can become complicated. What kinds of conflicts tend to arise between landowners and the parties who hold those easement rights?
Not surprisingly, it's rarely between the people who negotiate the easement. If you and I are making a deal and I grant you the right to drive across my property to access your property, we both understand the contours of the deal. Where it most often arises is the next person who owns one of the other properties. I might sell my property and the person who buys it from me may not like the fact that you're driving across what they perceive as entirely their property. And that's usually where I see the disputes. The other place I see the disputes, and I sort of laugh about this, but I have to check myself now because I used to refer to gentlemen of a certain age as the self-appointed mayor of the neighborhood. And there's a certain stereotype I'm referring to. I used to characterize it as a guy of a certain age driving a Ford with a topper on it. But I'm a guy of a certain age and I drive a Ford with a topper on it. So I got to change my stereotype a little bit. The issue there, though, is people get very territorial, and there's often a lot of emotion associated with these issues. So a person may buy a piece of property fully knowing it's subject to an easement. That easement may not have been put to use yet. And when the person holding the easement shows up to build a road or construct the power line, what have you, the owner of the property that is subservient, that is the property being used for the benefit of another, often objects and seeks to either extinguish the easement or severely limit the easement. And that's really where I see most of the disputes. The other big category is somebody seeks to change the use. And this is an area of a lot that creates a lot of litigation. You may be using the easement that I hypothetically granted you to access your single family residence, but it turns out you've got 20 acres and you want to subdivide it. And you want to go create 3 or 4 more lots and sell them off. Now the road across my property will be burdened not by one home, but by multiple homes. And very commonly, people object to that. And in those cases, it just comes down to the language of the easement. What was the easement granted for? And is the change in use contemplated and available under that easement?
Well, can you walk us through an example of a situation where an easement or right of way became a significant legal issue and what made that situation particularly challenging?
Well, many examples. I would say I have easement disputes almost always as part of the cases I'm working on. I can think back in one instance where an easement had been granted many years ago to a timber company for accessing timber and conveying logs across the property that my client owned. That property was then sold to a developer who was seeking to use that forestry access road as an emergency access to meet with county code requirements. And we raised the argument that that easement had been granted for a limited purpose that didn't include residential development and only included forestry. And it was, we thought, fairly clear. But the court looked at the language and interpreted it and did not find any restrictions on the use of the road. There was certainly language suggesting what it could be used for, but there was nothing expressly limiting that use. And so when I draft easements, and I'm often asked to do so, I like to include not just language granting a use, but language limiting that use. So for example, I might include in the hypothetical I used earlier, this easement is for a driveway to access a single family residence only and may not be used for multiple family residences. You could characterize that by the number of bedrooms in any manner that both parties agree to make it clear what the limits on that easement are.
Infrastructure projects like pipelines, transmission lines, or road access often require new easements. So, how do those negotiations typically unfold between the landowners and the entities that are seeking access?
Well, I'm going to preface this by a little teaser for a future episode. We're going to be talking about the area of eminent domain or condemnation in a upcoming episode. So I'm going to leave that aside. At the point where we're just describing an easement that is mutually agreed to, that would typically begin with the entity's landsman coming to the door, knocking on it, or contacting the landowner and simply inquiring about their willingness to convey an easement and what they might be willing to do and accept in exchange for that. So it's typically a negotiation. If the landowner is unwilling to sell and the entity has no other alternatives, then we begin to enter into the area of eminent domain. And I don't want to spoil the upcoming episode by going too far into that today.
Oh, I love a good teaser. So everybody has to make sure they come back for that episode. I'm excited about it. Well, for the last question, for property owners evaluating land that may already have easements in place, what are some of the key factors that they should understand about how those agreements could affect future use of the property?
Yeah, and depending on the complexity of the land deal, this would typically be a part of a standard due diligence. If you hired an attorney or an engineering firm, again, often we're called upon to look at some of these issues in connection with a transaction involving a large ranch, for example. And ranches often have multiple easements, rights of way, and related issues associated with them. So we run those down, find out how it's been used, sometimes contact the other owner, the other person involved, and ask them to clarify or agree to an easement so that we can eliminate some of the uncertainty in the future. Uh, Building on some of the examples I gave, if I saw an easement for a road that was being used to graze cattle, we might want to put in there that it's limited to use for grazing purposes or agricultural purposes, and not to be used in the future for development, as an example. So I think, again, it's incumbent upon the buyer to understand what legal rights exist on the property when they buy it, and to inquire, hire some professionals if necessary to survey and evaluate, and get that work done at the front end so you're not surprised after you buy the property.
Well, thank you, Peter, for breaking this down for us today. This has been an amazing conversation.
I enjoyed it. I'm looking forward to speaking again soon.
Yes, me too. Well, that's it for today's episode of Resource Law and Regulation with Peter Scott. If you'd like to learn more about Peter Scott and his work helping clients navigate land use, water rights, and natural resource law in Montana, you can visit scott-law.com. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.